everybody. Today, we are welcoming you to our webinar for domestic violence in Washington State Family Law Matters. Uh, my name is Tony Dellino. To introduce myself, I'm the Chief Operating Officer here at Dellino Family Law Group. A little bit about me. I help manage operations behind the scenes with Michelle and work on things operationally at the firm. Here's how it's going to work a little bit today. I'm here to moderate, and I'll be fielding your questions and making sure we get them answered. Michelle, our managing attorney, will be leading the discussion, offering all kinds of great advice. And submit your questions. I'll make sure that we get them answered. To do so, the bottom of your screen, there is a Q&A button. So you can enter your questions via the Q&A section, and they'll come to me. And there's an option to mark them as anonymous. And so if you don't want your name seen by the other people that are on the webinar, feel free to mark them as anonymous. And then Michelle will help guide the conversation. And yeah, so I'll get the questions answered. We'll get it going. And so here's Michelle Dellino, Managing Attorney of Dellino Family Law Group, to run the webinar.
Hi, I'm Michelle. Thanks for being here today. We're going to talk about domestic violence. Before we do, I'll tell you a little bit about me. I've been practicing family law for almost 15 years. Dellino Family Law Group has a lot of attorneys that do a lot of really difficult work, and some of that focuses on domestic violence. Unfortunately, domestic violence is a big part of family law. It also can have implications not only in your case, but in other considerations you might not have thought about. So we'll talk a little bit about that today. Anything that I am an attorney, but I'm not your attorney. So anything that I say today is not legal advice. You can't rely on it for legal advice. It's simply information. If you have very fact-specific questions, best thing for you to do is consult with someone one-on-one, whether it's me or someone in this firm or another firm. But to get legal advice about your own particular information, situation and information, you need to consult with someone and have confidentiality. There's no confidentiality in this webinar today, and there's no attorney-client relationship formed. With that being said, I do have a lot of information to share with you about domestic violence in Washington State family law, what that means, and we'll start just with that. So domestic violence, a lot of people hear that term and you're like, what does it really mean? Well, in Washington, it means very, very specific, clearly defined actions that are within what we call a statutory definition. So what that means is I can say, oh, I think that's domestic violence, but unless it fits within the definition of what the law is in Washington, as far as the court is concerned, it's not. So this is something for you to know. If someone says that someone yelled at you and they were mean to you and you think, oh, that they do that all the time, that's domestic violence, probably not. It might be, but it really depends on if it falls under the definition of it under Washington law. So there's a statute in Washington, and some people like to look this kind of stuff up, so I'll tell you what it is, but you certainly don't need to do that. It's RCW, which is the Revised Code of Washington. It's 7.105.010, and that lays out a lot of information, but most specifically, it lays out the definition of domestic violence under Washington law. So to know what DV is, you've got to understand what the law thinks it is. The definition of domestic violence in Washington changed last year to expand and add a whole new section called coercive control. So we're going to talk about that a little bit today. But instead of starting with coercive control, I'm going to start with what the definition of domestic violence in Washington has been for many years in the first part of the statute. So domestic violence first means the first thing everybody thinks of: physical harm. Physical harm, bodily injury, assault. So any kind of physical harm, like I hit you, I slapped you, I pushed you, that's all DV. Second part of that definition, this is also long been the case in Washington. You might hear someone refer to a DV case as an imminent fear case, because the second part of the statute is infliction of fear, harm, bodily injury, or assault. So the infliction of fear. So what that means is someone hit me is the first part, or struck me. The second part is someone inflicted fear that they were going to do that. That is enough to be domestic violence in Washington. Whether that fear is reasonable is a whole other thing. You can't just be like, I was scared, so it's DV. No, but if someone grabbed, like something like this and was like, I'm going to do this, but didn't hit you, that might cause a reasonable person to feel fear. So that would be domestic violence. Someone, well-established examples of this are punching holes in a wall next to someone, things like that, that they didn't even have to put their hands on you, but they made a reasonable person feel in fear for their physical safety. So that is DV in Washington, in addition to the actual bodily harm. The next part of the statute that has long existed is non-consensual sexual contact or non-consensual sexual penetration. So basically rape, if someone has a forcible penetration that's non-consensual, depending on whether it rises to the criminal definition of rape, it is domestic violence. Sexual contact also too, penetration of another person is not required to be DV. Sexual contact, molestation, touching, any kind of groping, any of that also can be considered domestic violence. Unlawful harassment. Harassment can be handled as well under another statute that deals with anti-harassment, but when there is a relationship, whether it's a dating relationship or a family relationship that puts you in the domestic violence category, unlawful harassment is also now domestic violence. And then stalking of one former intimate partner by another or current intimate partner is domestic violence. So stalking someone electronically, monitoring them, following them, that is also domestic violence. So that's really, really important for you to understand. The last part of it is not only is it physical harm, infliction of fear of physical harm, sexual assault, basically, or sexual touching, harassment or stalking, it's also coercive control. So coercive control means a lot of things, and I'm going to come back to that and talk about that a little bit later because that could take up a lot of time. I want to make sure to get to the rest of the information for you. So now that you know what domestic violence is in Washington, what happens? Like, what do you do if someone does something like that? Well, in the family law context, first of all, if someone commits domestic violence against you, you should call 911. And the biggest thing, the reason for the protection order statute is that doesn't happen a lot in dating type cases, because what happens? Someone does something to you or in a marriage, and you don't want them to get them in trouble. You think they didn't mean it. They're sorry. You don't want them to go to jail. You don't want all these things to happen. So a lot of times violence doesn't get reported. And then it happens again. And someone maybe thinks about doing something. Maybe they call the police and they don't want to press charges, whatever it is. But there's a lot of late reporting or non-reporting when it comes to DV for obvious reasons. And no one should pass judgment on that. But the protection order statute in Washington is meant to deal with, so there's two kinds of things, I guess I should say. The first part is I reported a crime of DV, that person got arrested and they get charged with a crime. That's a pretty obvious, straightforward thing. That doesn't always happen. The second part is I didn't call the police, but later something happened and I needed to get a protection order to protect myself. Okay? You do not have to have a criminal case to do that. If you have a criminal case where you're a victim, there probably will be a no contact order in that case. That's different than a protection order, and that's part of a criminal case. But let's just assume no one called the police, no one did that, and now you feel you need protection and something has happened. So there is a protection order statute that looks to that definition I just talked about and takes people through a process of being able to seek protection. So we're going to talk about that today. We're also going to talk about how a finding of domestic violence can impact your parenting plan. Parenting plans in Washington are necessarily established if you get divorced or if you end a relationship with children. You can have the court put a plan in place that says who spends how much time with the kids, who has the opportunity to make decisions for the kids, and sets forth a holiday schedule and all kinds of really important information. A finding of domestic violence, whether it's in a criminal case or in a protection order case, is a basis for restrictions in your parenting plan. So that's really important to know, because if you, let's say, got arrested for misdemeanor assault and you and your spouse work it out, everything's fine, but you pled guilty to it, or you pled guilty to a lesser offense that says I committed domestic violence, and you didn't have to go to jail and nothing really happened. Okay, but then later you get divorced and you have that finding of domestic violence and it involves your spouse and potentially your kids were home or whatever it is, you have that finding, that can be a basis to restrict one party's time with the children and restrict decision making. Very often a divorce case will start because DV happened, and then that can have very serious implications for someone. Unfortunately, sometimes a case will start with false allegations and someone will say that the other person did this or did that to try and get restrictions in your plan. So understanding that there are those kinds of implications is really important. Criminal cases, domestic violence in criminal cases, like I said, unfortunately, a lot of the time these cases, it doesn't get reported, or one party changes their mind and doesn't want to move forward with assisting in a prosecution, so the cases get dismissed. But the reality is domestic violence cases in court can be really difficult to prove without the accuser being willing to say, yes, this happened, because typically DV happens behind closed doors. That's just how it is. It happens at your home while no one's there. It happens, in the privacy of different spaces as opposed to out in the open for everyone to see. A very common thing with people who are domestic violence perpetrators is that they might seem one way in public and another way in private. And so that is why DV cases can be hard to prove, because a lot of the time someone doesn't want to go through with that, or it really becomes a he said, she said, or some variation of that. So there is another instance where domestic violence happens a lot, and that's in the context of also substance abuse. So if someone's dealing with substance abuse and chemical dependency issues, that very often is a catalyst for DV when it otherwise might not be. So when you're back dealing with a criminal case or a protection order case, it's very common for chemical dependency evaluation to be ordered by the court, because if it seems that the domestic violence is also has chemical dependency underlying it. Domestic violence evaluation will also be ordered in a criminal case or in a protection order case if a protection order enters, because what the court will want to do is they'll want someone to get evaluated. They'll usually be assessed a certain risk level, and then they'll have treatment that they have to comply with as part of the order. So both of those kinds of assessments can play in. Family court can also order either of those, whether it's in the protection order context, the divorce context. There's a lot of broad authority given to courts to order those kinds of assessments. So I hope that's helpful. Tony, is there any questions before I start talking about the protection order process?
Yeah, we do have one question in the chat. I will also use this time to remind everybody, if you have questions, please type them into the Q&A section there below. One question does come in looking for clarification, I think, as to whether or not emotional, physiological, and financial or verbal abuse are considered DV in Washington.
Potentially. That comes back to coercive control. So I'm going to talk, you know what you asked, so let's talk about coercive control. Prior to a change in the statute in the last year, verbal abuse was not domestic violence in Washington unless it was a threat to harm someone. Like if someone says, you've all had the situation, or maybe not all, but most people have had the situation when you're like, I was so mad I could kill him, right? And did you really mean you were going to kill him? No, but you also, or maybe you be like, I want to kill you to your spouse or something. You're angry, you're frustrated. That's very different than I'm going to kill you. That's very different than that, right? So that is probably going to be domestic violence because it's that imminent fear prong I talked about, where it puts someone in imminent fear of bodily harm. So those words have always been considered domestic violence if they're a threat of imminent bodily harm. However, prior to the change to add coercive control to the DV statute, just verbally assaulting or humiliating someone that way was not DV. Now we have coercive control. So I'm going to explain what that means. It's a little bit nuanced, and it's not, I say this with some trepidation because in doing coercive control cases since the law changed, I've seen a wide variance in what courts will accept as coercive control. There is a definition, so I'll go over that with you. And we can talk about some examples because fortunately the statute includes some of those. So coercive control is a pattern of behavior that is used to cause another person to suffer physical, emotional, or psychological harm. So it's a pattern of conduct used to cause somebody to suffer emotionally or physically or psychologically. And in purpose or effect unreasonably interferes with a person's free will and personal liberty. So it also has to interfere with someone's free will. It's not enough to just be like, you're terrible. A lot of times people will be, verbally humiliating. It also needs to interfere. It unreasonably needs to interfere with someone's free will and liberty. In determining whether that interference is unreasonable, the court will consider context and pattern of the behavior from the perspective of someone else in the same situation. So if a reasonable person or anybody in that situation would feel this way, then okay, it's probably coercive control. If somebody just said to you, I don't like your shirt, and they told you every day, I don't like your shirt, that might be a pattern, and it might make you feel like it's interfering with your free will to wear that shirt, and it might feel threatening to you, but that's not going to be coercive control because a reasonable person wouldn't feel that way from you saying, I don't like your shirt. If someone was saying every day to you, you are a piece of crap and you're never going to amount to anything, and if you try to leave, you're going to have nothing, and things like that, if someone said that to you every day, that's coercive control. So there's a big difference there. Examples of coercive control are engaging in any of the following, and these are from the statute: intimidation or controlling or compelling conduct by, and this is really important, damaging or destroying property or threatening to destroy property. So that's one part of it. If someone is banging holes in walls, if someone is like, I'm tearing apart your family photos that are important to you, and I'm, if you don't stop, I'm going to do this. Damaging property or threatening to is coercively controlling according to the statute. Forcing the other party to relinquish goods, property, or items of personal value too. Like, I'm going to take, you have probably heard about or can imagine a situation where someone is like, I'm going to take that away from you. Like, I have this baseball in my office that's been sitting in my office a long time, and if someone took it from me, I'd be pretty upset. And so if someone was, I'm going to take this from you and I'm not going to give it back to you unless you do what I say or whatever, that's coercive control. It's not just like if someone picked up this pen and walked out with it, no one cares. But if it's depriving me of something that is important to me and it's done in an intimidating and controlling manner, that is coercive control. Another example of coercive control, according to the statute, is the use of technology to threaten, humiliate, harass, stalk, intimidate, exert undue influence over or abuse another person by engaging in cyber stalking, monitoring, surveillance, impersonation, anything like that. So we live in digital information era. Everybody's on social media, everybody's online, people are filming things all the time. So a really common thing that we see, which was not DV before, but is now, is someone was sent personal intimate images, or someone has a video of someone that is personal and intimate, or someone was sent a Snapchat or whatever, and someone does something with that and they say, oh, I'm going to send this to your whole family if you don't do what I want, or they do send it to your whole family, or they do post it online. That is domestic violence. That is coercive control. So you should not, that's one example of it. Also, too, monitoring someone through those kinds of channels electronically, stalking them electronically, using electronic communication to harass someone, messaging someone, all of the things in that vein are coercive control. Another example is carrying, exhibiting, or drawing or threatening to use a firearm or other weapon that could produce bodily harm. That obviously falls under both coercive control, if someone's using weapons to threaten you or saying they're going to, and the imminent bodily fear prong. So you were asking about verbal assaults, and intimidation and threats and harassment can be coercive control. They're not always. The question is it reasonably, would a reasonable person find that threatening to the point that it's damaging emotionally and psychologically? So it's a lot to unpack there. I think for the most part, most people in the Washington legal community think it's good that the statute has been expanded to include coercive control and those related considerations. I will say that it can be abused. And I have seen some people bringing domestic violence petitions on the basis of coercive control when it's kind of been a stretch, or it's just, a lot of people will say, gosh, you could read my text messages to somebody I dated at some point out of context and it could look bad, right? I mean, so it opens the door to a lot of things to be considered and evaluated that really never were before. So that's not necessarily a bad thing because it does allow protection for more people, but sometimes it can lead to more opportunities for things to be used in the sense of abusive litigation. So that is a little bit more about coercive control. Okay, I was going to talk about the protection order process. Is there anything else on that or anything else before I move forward?
The only other question in the queue is asking for more explanation about what is assessments.
Oh yeah, we'll talk about assessments. You want to talk about that? I'm going to talk about it in this process, but I'll talk about it now anyway. An assessment. Did I say assessment or valuation? I think it's the same word. Sometimes I'll use one word, sometimes I'll use the other. So if you've never been involved in the court system in your life, lucky, good for you. Hopefully you aren't. But if you are at some point, you will find out, and there is DV or chemical dependency, which is the same thing as substance abuse. Those words are often used interchangeably, and you might not know them because you don't speak this language. Assessment and evaluation, same thing. You might not know that. Hopefully you never do. But if you do, if there are chemical dependency or domestic violence issues in your case, you or the other party may be ordered to undergo a chemical dependency or domestic violence evaluation or assessment. You might also be, and I'll tell you what that is more in a minute. You might also be ordered to undergo psychological assessment or testing as well, depending on the situation. So what is it? Well, let's start with DV. If you have kids involved and you are found to have committed domestic violence and a protection order entered, or even if you don't have kids involved, this happens sometimes, you will be ordered to undergo a domestic violence assessment, and you'll have to do that with a registered state agency that is capable of providing what we call DVIT. DVIT treatment is domestic violence intervention treatment. And so you'll go to an evaluation, you'll answer a bunch of background questions, you'll take some tests, they'll basically assess you and talk to you. And they'll also review the allegations of domestic violence, they'll review any criminal history, they'll review any other court history, and they will talk to what are called collateral contacts. Collateral contacts are going to be like your spouse. They're going to be other people that are close and know you and know what's going on. Or it might be like if you have kids, it might be other people that are connected through your children or whatever, but they will talk to these collateral contacts and will always include the other party. And they'll use that information as well. So it can't be a one-sided evaluation. You can't be like, oh, this has never happened before, everything's cool, this was a one-time, one-off thing. And then you have 5 people being like, no, I've seen this happen a million times, and this was kind of the straw that broke the camel's back. So, and it's not to say that everyone's going to believe everything the collateral contacts say either, but it is a balanced evaluation that includes external reporters. It can also include like your therapist or whatever. So it's not all bad people they're going to talk to for you, but it's important for you to know that's part of the process. So then an assessment is done, and then there will be you'll be essentially given a risk level, and you'll be a certain level of offender, or you'll be found that you don't have a problem, or no treatment's necessary. But if you're doing an eval, treatment of some level is probably going to be necessary. So in that kind of a situation, you will have follow-up treatment, whether it's domestic violence DVIT treatment for 6 months or a year, whether it's a combination of DVIT and DV-DADS, if there's kids involved, which is the second part of the treatment, whether there are other recommendations that can happen, whether it is what's called DV-MRT, which is domestic violence moral or cognizance therapy. There's a lot of different things. I mean, I can talk about DV all day. I also used to be a criminal defense attorney and have defended hundreds of people against domestic violence charges, and also helped people through those kinds of situations. So I could talk about DV all day. But to sum it up, DV evaluations are different in the family context than the criminal context. In the criminal context, they're usually not going to talk to collateral contacts, and it's a much simpler evaluation. In the family law context, they are going to talk to the other party. They are going to talk to other relevant collaterals, including therapists, and they are going to recommend probably a higher level of treatment, which is DVIT, as opposed to DV-MRT, which is more common in the criminal context. So that is what happens in a DV evaluation. And really, here's the thing. If you are under an evaluation and you have a DVPO, domestic violence protection order, in place, you better do the treatment. If you don't do the treatment, the other party is going to be able to continually get that order renewed. You're not going to have more time with your kids. You're going to be found not in compliance. You need to do the treatment if you're ordered to do it. It won't feel good. You won't want to do it. You might think, I don't have a problem, this was a misunderstanding, they made this up. That all very well could be true, but do the treatment. If you don't, it's just going to compound the situation, and it's literally going to look worse. I also touched on chemical dependency evaluations, and I won't spend a lot of time on that, but I'll just tell you it's the same type thing. In a criminal context, everyone that's arrested for DUI or a domestic violence charge where there's any kind of alcohol element, like this happened when people were drinking, they're going to be asked to do a chemical dependency evaluation. That chemical dependency evaluation in a criminal context is going to be very different than a family context. No collateral contacts. They will review your criminal history, your driving history. They'll talk to you about your experience with alcohol. They'll give you a UA, and they'll give you a class recommendation. And sometimes you'll have a long recommendation, but usually you'll have like a one-day recommendation, to be honest with you. In the family law context, if you're doing chemical dependency evaluation, it will include the collateral contacts, and there typically will be a longer recommendation, and it will take into consideration whether you're also doing DV treatment. So, and some people can do a dual assessment, but usually you have to go to 2 different people for that. There's also psychological assessments, but I won't talk about that today. So I hope that was helpful. There's a broad range of different kinds of things that can be ordered as far as treatment goes, but pretty much they say, do the evaluation and follow the treatment. And I have to tell you, you really, really should follow the treatment. And again, this kind of comes back to, a lot of people, and I don't know if anyone on this webinar or that's watching this later will fall into this category, but I'm going to bet some of you do. You have been falsely accused of domestic violence. It happens. That's not to say that some people aren't actually really the victims of domestic violence. That happens too. And it can be very difficult to sometimes know what's true and what's not, but I will tell you that in doing this a long time and handling domestic violence in thousands of situations, you start to see people that are using domestic violence as a shield, which is what they should be doing. You use a protection order statute, you use the court process to shield you from further violence, whether it is harassment, verbal, or whether it's physical. You use the process to shield you. There are also people that will use it as a sword. And those people are the ones that are attacking those of you who maybe didn't do anything, but they know it's simple enough to make allegations of domestic violence and try to appear credible and get a treatment recommendation against the other person and restrict that person from time with their children and basically destroy their lives. And so that can happen too. The goal is to defend yourself in those situations as early and often as possible. But it happens. So both sides of the coin happen. And the protection order statute is important because I started off earlier by saying a lot of people don't report DV for good reason. It's a terrible cycle. And a lot of people fall into that cycle of, I thought it was never going to happen again. And then I thought it was never going to happen again. And then I thought it was never going to happen again. And so there are very often many times that someone doesn't call the police. And so the protection order statute, the legislature acted to put something in place so you could still get protection even if you didn't have a criminal case. And so that's good. And it's very necessary in many situations, very necessary, but it's also can be abused. So it's important to point that out. So I'm going to talk about the protection order process. Tony, is there anything else before I do that?
Yes, there is.
All right,
So
I'll
this
pick one more.
question, okay. This person's asking about, they said they got a DVPO, domestic violence protection order, because my ex physically hit me. What should I do if he's trying to get my details from a third party? And what do I do if he's talking bad about me to common friends, telling me not to contact them, spreading rumors, things like that?
Is there, okay, say that one more time. Spreading rumors,
Sure.
read it to me again.
Sure. I got a domestic violence protection order because my ex physically hit me. What should I do if he is trying to get my details, get details about me from a third party? And what do I do if he's talking bad about me to common friends, like telling them not to contact me, spreading rumors, things like that?
Okay, that's two different things. That's what I thought you said. That's two different things. One, if he is attempting to contact you, every domestic violence protection order is going to say no third party contact. So if he's trying to contact you or send messages or do anything of that sort, then it could be a situation where that's third party contact and it violates protection order. If a party violates the protection order, you should call the police and make a report. And if you do that, let's say if you do that, then that person can be arrested for violating the protection order. And violating a domestic violence protection order, even by third party contact, is a gross misdemeanor. If you do it 4 times, it's a felony. And 4 times can just mean 4 phone calls. So that's really important to know. But if you have proof that he is doing things like says, oh, tell, Susan XYZ, that's third party contact. If he is telling people, that's different though, than if he's just telling people, hey, don't talk to her, don't talk to Susan, Susan's a liar. You can't really do anything about that. That's not a violation of the order. He can say whatever he wants to people, unfortunately, unless it's harassing or threatening or falls under one of those other categories. But if it is a situation where he is, directly passing messages or saying, say this or say that, or you let her know, she better be sorry. It's like that kind of thing happens. That is a violation and you should call the police. So, and they will take it seriously. That's the thing too. A protection order is the highest level of protection. There are different kinds of orders. I've done a webinar before on the different kinds of orders, so I won't redo that here, but there are domestic violence protection orders. There are no contact orders that I mentioned being in the context of the criminal case. And there are restraining orders, which are civil orders that are issued in the context of like a family law case or other civil case. Domestic violence protection order and anything under the protection order statute is a higher level of protection. And that means that you're going to get a response from the police pretty quickly because there's a law enforcement information sheet on file that tells them this is a DV issue. So if you say that someone violated this kind of an order, you're probably going to get a response fairly quickly as well. So hopefully that is helpful to you. But I do want to talk about, and I could probably just answer questions all day. That's a lot more fun, right? And I'll take a few more, but let me just touch on basically the protection order process and what it is, because this is really kind of the nuts and bolts of domestic violence practice in Washington, where you don't have a criminal case. This can be done in tandem or as a companion with a divorce case or a parentage case or whatever else, or it can be done on its own as what I would call a standalone protection order action. So domestic violence, the DVPO provides protection to individuals who are the victims of DV that fall into one of those categories that I talked about earlier. So they call it a DVPO. You'll probably hear that, a DVPO in Washington. A DVPO is a court order that aims to prevent further harm from preventing one person, the restrained party, to have contact with the other party. And that can be third-party contact, it can be phone contact, text contact, it can be any contact at all. It doesn't have to be I'm in your face. It can be any contact at all. And so in order to be subject to one of those orders, you have to fall into a certain category. So you must be a victim of domestic violence. The other person must be the perpetrator. Domestic violence, again, it's physical harm, stalking, assault, infliction of fear of doing any of those things. It can be other abusive behavior, including coercive control, stalking, or harassment. Eligible, though, you have to be eligible to get a protection order or to be a protected party. How do you do that? It means that you are either former partners, intimate partners, former spouses, former dating partners, or you're any of those things currently, or your parents or children or siblings. So if you are family members, close family members, or you are dating or were in a dating or marriage-like relationship or intimate relationship, then you have the relationship component of it and you have the domestic violence allegation, then you can get a protection order. So to get a protection order, you need to file a petition. And this is the one thing about protection order access, is they've tried to make it pretty easy. I wouldn't say that everybody would agree it's easy to do, but they recognize that a lot of people doing this, you don't have an attorney, you're trying to figure this out on your own. So there are domestic violence advocates in Superior Court that will help you. I think they still have them in district court too, although I'm not totally positive how many there are anymore, especially in King County, but there are a few. You can go to a local district court. There are some district courts that are throughout King County or Snohomish County, or you can go to Superior Court. Some cases that have cases with children will be transferred to Superior Court. Some other cases, if there is another family law action, will also be transferred to Superior Court, but you can seek a temporary protection order. So that's the first thing that you do. You go, you fill out a petition, you say why you should get this. They will somewhat help you. They won't give you legal advice, but they'll help you on how to fill out the forms. And then if the court determines that you are in immediate danger, it may grant you what is called a temporary protection order. And it's known as what's called an ex parte order. If you've ever heard ex parte, it's EX space PARTE. And that means one party, like one person went and got that. You didn't have to give notice to the other party that you were doing it, because the court's like, oh, I have your petition. This is a dangerous situation for you. I'm going to give you some temporary protection. So then a temporary order is issued. And typically what happens then is that order gets served on the other party by law enforcement. And there is a return hearing, like there's another follow-up hearing, because that temporary order is going to expire. So there'll be a return hearing, typically in 14 days. So in 14 days, sometimes longer if the court needs to do that, but it's supposed to be 14 days. And then before then, the other party will have the opportunity to file a response to what you said. And then you'll have an opportunity to file what's called a reply to what they said. You get the last word because you're the petitioner, but they have to have notice of this hearing, and they have to have opportunity to respond, and they have to be served in a sufficient amount of time, or your hearing's probably going to have to be continued, and that temporary order will just stay in place until then. So notice and opportunity to respond is really important, because if you're anybody out there, like I mentioned earlier, that's been accused of DV that didn't do it, you need to prepare a good response. And sometimes someone's not going to believe you, but you still need to prepare a good response and make a record, because there is a whole process for you. There's an appellate process. If your order is entered by a court commissioner, there's a right to revision by a sitting judge. There's a process that you're going to go through. So you want to make a strong record if you're being accused of domestic violence, even if the order enters to say, I didn't do this, and to put sufficient evidence in the record to show that maybe you didn't do it. The standard of the preponderance is what we would call the standard, like the burden of proof in a case like this. It's very different than the criminal context. In the criminal context, if someone wants to prove domestic violence, it's like I told you, it needs to be proved beyond a reasonable doubt. And after many years of doing defense work, that's a lot of the reason why these cases don't go to trial, because I'm kind of like, we've got reasonable doubt and the other person doesn't want to come and testify about it. You can't go forward. There's a lot of plea bargaining, a lot of that kind of things happen. That thing happens, or a case just might get dismissed. In the civil context, the protection order process, at that return hearing, the court must find by a preponderance of the evidence that the domestic violence occurred. So that's not a very high standard. That's not like beyond any reasonable doubt. That's like more likely than not. That's like 51% chance it happened, 49% chance it didn't. It can be a close call. And sometimes you'll hear a court say, this was a really difficult decision. So it's really not uncommon. Another important thing to know is that that order could enter for a year. It can enter for 2 years. In some circumstances, it can enter for a lot longer. If it does enter for a lot longer, there is a process to try and modify or terminate a lifetime order or a very long-term order, and that's a whole other thing that you need to do, but it is a possibility. Domestic violence protection orders are supposed to be granted for a year, sometimes 2. But the thing to know about this is if the court, when I mention these longer orders, if the court deems that it's necessary for someone's safety, they can enter it for longer. So there's a lot of discretion that's given there. And that is also why you want to make a strong record, because you might want to seek to challenge that kind of a long-term finding. A victim can also request a renewal, and this is important. I've done a lot of renewals, and they're it's tough for people. So a renewal of a protection order before it expires, if your protection order is nearing the end and you think, hey, I feel safe with this order, but it hasn't been very long and this person hasn't done treatment, or you don't even know if they've done treatment, you're just still really freaking scared, you can request your order be renewed, but you don't want to let it expire to do so. In that kind of a situation, the other party gets served with renewal. And now the person that gets served with renewal is like, wait a second, I haven't seen him in a year. I don't know what he's doing. How can this be renewed? I thought this was finally going to be over. The answer to that is that it's not required for you to commit further acts of domestic violence for a renewal. There's a presumption that it's going to be renewed. And what happens is the burden of proof shifts. It shifts to the person who is the restrained party, the person who has the order entered against them. And that person needs to prove that they will not commit further acts of domestic violence. That's really hard for 2 reasons. One, it's hard to prove a negative, that you won't do something. 2, a lot of the time the person under the order is like, I didn't do this in the first place. You don't get to come back on renewal and say that was a lie, because guess what? It's automatically going to enter if you do that. It's already been a finding. You have to accept that. This goes back to one of the very first things I said, do the treatment. If you don't do the treatment, it's absolutely going to renew. Most of the time, if it's the first time, it's probably going to renew anyway, because there's a strong public policy movement, I would say, to err on the side of caution when it comes to protection orders. And there does not need to be a finding of DV. You really have to prove that you're not going to commit further DV. And the best way to do that is treatment, changes in your life, and being able to show that to the court. So that's a little bit about renewal. I would say too, that for most people, if you have an order, you want to keep that order. And a protection order is a stronger order of protection versus a no contact order, because at a certain point, a no contact order with a criminal case will expire, or it'll be done unless the court enters like a lifetime, which doesn't happen very often in a criminal misdemeanor case. Sometimes in a felony, there can be really long orders, but it's pretty rare. It's not a renewable order. A restraining order is also not a renewable order. It's for a certain duration of time. A protection order is really the only order that can be renewed. So you want to be aware of that. It's really terrible when someone's like, I didn't realize my order expired, and then you're in a tough situation of having to deal with that. If you're the person who renewal is being sought against, like I said, the burden's gonna be on you to prove that you're not going to do it again. But if you are the person who is the restrained party, I talked earlier about what to do when someone is, trying to have third-party contact or violating the order. I have defended many, many people over the years who didn't realize they were violating an order, or they got served with an order. And so this is really for those people. You get served with an order, you read it, and it says, don't contact this person. And the first thing you do is you text them and you're like, I can't believe you did this. You lied. I can't believe this. Or you call them. You just violated the order. So like you're going to get arrested. So like, or not arrested, you're going to get a summons to come to court and you're going to get charged with a crime. So end of the day is it's terrible when this happens, but do not react by, sending a bunch of messages or calling people. The other thing to know is that a lot of the time you might start a family law case or someone might start one against you and you're really upset. And so you're contacting this person and you're following them and you're trying to get their attention. You're texting them 100 times and you're calling them and all these kinds of things. And then that falls into some of these patterns of DV because the other person has said, don't contact me. And then the person will go and get a protection order. So don't give someone that kind of a reason. Instead, find other ways to deal with your emotions and don't victimize that person. Like they don't want the contact, don't force the contact and think that you know better. So those are just some things that very commonly happen, for lack of a better term. Before we wrap up, are there any other questions?
One last question. Oh, one just popped in. One other question first. Related to what you're just talking about, I think they're asking, well, what do I do with evidence or such things like text messages, emails, photographs that are related to DV?
If you have that kind of evidence, keep it. If you have text messages, our family wizard is often used in family law cases. You have documentation from that. You have Instagram messages, screenshot, keep them, emails, keep them. Anything that is evidence of DV, you would want to keep if you are going to have one of two things. Number one, if you're going to bring a family law action, you're going to want that. So keep it and then give it to your attorney. And number two, if this person's been doing something to you, you can provide that to law enforcement as well if you need to, if you are calling the police and making a report. So keep evidence of domestic violence. Don't get rid of it because you might need it. Or the other side of the coin is if you have a bunch of communication with somebody, and I've had this happen before, and the communication is just shows relationship communication, you're not threatening them, whatever. And then they make claims of domestic violence. Your communication history can also be helpful because it can show that's not what happened. This person wasn't afraid. That's only like a snippet of the conversation. If you look at the whole thing, I was joking, and that's very obvious. So things like that also can be helpful as far as communication.
Great. Last questions just came in. Questions about guardian ad litem, and specifically saying that there has been overwhelming evidence that there are DV concerns, but they're not showing up in the guardian ad litem reports. So is there a way to hold the GAL accountable so that they aren't a GAL on future cases or putting other people at risk?
Well, the GAL doesn't think that there is. So why? Did they not talk to the right people? Because that could be a thing too. You're going to have, I'm not saying that there's not, and I don't want to sound like this. I don't want you to think, oh, everything a GAL says is right, because that's not true. I've had many GALs discredited or gotten their reports thrown out. But at the same time, it's a high burden to do that, and you're going to need a competing expert. So if you have a GAL report, this is just a basics about a GAL report or a parenting evaluator report or a family court services report, and it's not favorable to you or it doesn't include things you think it should say, you might need an expert to show why the report is wrong or misses key things, or you might need an attorney to expose things that they did or didn't do. But generally speaking, if you're saying there's overwhelming evidence and the GAL report is saying there's not, there's some kind of disconnect. Either that evidence hasn't been presented to them in a way that makes sense or that's credible to them, or they don't have the information to get it. They haven't talked to the right collaterals, or they don't believe you and they don't think you're credible. So, and I'm not saying that any of those things are true. I'm just saying, figure out what's the missing point here and figure out how to challenge that report. If you're just wanting to make a complaint against a guardian ad litem, you can definitely do that, but I would highly recommend you don't do that while your case is pending. It's not going to look good. Wait till the case is over.
Perfect. One last question about protection orders. How do I file a protection order? Do I go to the courthouse only, or what the process?
Yeah, go to the courthouse. If you're not doing it with an attorney, the easiest thing, I mean, there's an online process now too, I think, that pro se's can access. We can access it. I don't know how it works. A pro se is an individual representing themselves. I don't know how you do it online if you're a pro se, so I don't want to tell you that, but I do know you can go to your local district court. You can go to the Superior Court downtown Seattle, or in Kent at the Regional Justice Center. In Everett, you can go to Snohomish County Superior Court. You can go to Snohomish County District Court in Linwood. There's one in Arlington and there's one in Monroe. In Tacoma, you can go to Pierce County Superior Court downtown. There's also District Court. So you go there and you tell them you want a protection order, they'll help you fill out a petition, and then you will be able to see if the court will issue you a temporary 14-day order. But you go to the courthouse or you access it online if that's possible. I think it is. I just don't know the specific mechanics for somebody who's unrepresented. For attorneys, it is. So I hope that helps. This is really, really important information. I can't stress to you enough how much every day in my office we talk about either somebody really being a victim of DV or somebody being falsely accused of DV. There's so many different ways to look at it in different situations. And if you're watching this, you're dealing with one of those situations, and that's really tough. So whether you're accused or whether you're a victim, you know, getting resources and access to help is extremely important. And you took a big step and hopefully got some more information by coming today. So we really appreciate it. I wish you the best, and feel free to join us next time for another webinar. We also host a meetup group, which was, my gosh, it was just last night. That feels like a long time ago, but we do host a meetup group online, typically once a month, that also meets in person. There will be another meeting of that. I believe it's September 27th in Bellevue, so you can feel free to look at our website and get access to that if you'd like to come and ask questions. Otherwise, if you're local, if you're not local, we do a webinar monthly as well as part of our education series. So again, thanks so much and have a great day.
Thanks, everyone.